We are about to start the last, but not the least, panel of the day. And I would like you all to take your seats, get comfortable, and prepare to be amazed. I know it has been a long day and a long week for all of us, but I promise you, we will have a very good panel today with amazing panelists. I hope you all share the same excitement that I'm having right now, because I'm a really fan of all of the panelists here. For the next hour, we're going to talk about technology and regulation. As Professor Wilkins said yesterday, technology has been changing not only our lives, but especially our profession. As lawyers and judges, we have been facing a brave new world, full of expressions that until very recently were not that familiar to us, and maybe still are strange for some of us here. Yesterday, we heard about artificial intelligence, automatic decision, document automation, knowledge management, online dispute resolutions, ODR, online courts, and even an app which is pretty similar to an Uber for lawyers. I'm not gonna cold call anyone here like asking about these concepts, but I'm pretty sure that most of them are really new for almost everybody here. So these innovations can make some of us scary and worried about the future, but we are not alone, because the governments and especially the bureaucrats are also afraid of these innovations. And because they are afraid, sometimes they cannot follow this ever-changing world, and regulation sometimes can be an instrument to prevail this kind of innovation. Especially in the legal profession, where the bar associations and UPL regulations, UPL stands for Unauthorized Practice of Law, in Portuguese, exercício ilegal da profissão. UPL regulations can restrict the entry of competitors in the legal service marketplace. Considering this sort of amazing but scary context, the panel will address the following questions. First, how can regulation foster innovation? In what extent UPL, unauthorized practice of law, I hope you all remember this expression because it's going to be important. How UPL can work alongside technology. What kind of metrics can we use to measure the quality work produced by lawyers and judges? What is a good job produced by a lawyer or a judge? What is a good work produced by a law student? I hope you, Professor, don't remember about that when I deliver you my paper. And what kind of ecosystem of barriers prevents innovation to happen in society and in the legal profession? To answer these questions, we have here today a panel of two specialists on the subject, who I had the pleasure and honor to be my professors. First, Professor Ron Dolin. He's a lecturer in law at Harvard Law School and taught the best course that I take here at Harvard on the impact of legal technology and the practice of law. He's also an amazing person and a very funny guy. He holds a BA in math and physics from UC Berkeley, and also a PhD in computer science from UC Santa Barbara. He calls himself an engineer, not a lawyer, but he was one of the first 100 employees at Google and left after several years to take a law degree. I don't know exactly why he did that, but he's also a licensed attorney in California, so he's an engineer and a lawyer. Professor Gustavo Binenbojm, who is a full professor at Rio de Janeiro State University, my alma mater. I had the pleasure to be one of his students during my master's degree. He holds an LLM degree from Yale Law School, unfortunately, and a PhD from UERJ. Binenbojm is a practicing lawyer with extensive courtroom experience. He has argued several landmark cases before the Supreme Court of Brazil.
What about my course? Isn't it the best?
The best course that I take during my master's, of course, of course, of course. Thank you. Yeah, I've been graded, so. And Professor Vitor Schirato, who is a professor of admin law at the University of São Paulo. He was an LLM degree from Osnabrück University in Germany and a PhD from also the University of São Paulo. And he was also on my panel, on my master's, and he's an amazing professor. And I really wanted to take his course, maybe at USP sometime.
What am the best thing?
A what?
What is my best thing? Because this is the best course.
You're a great panelist. It's like a wonderful guy. So you can ask questions to the panelists using our app. I believe you all know all of them, like the Slido here. And each of the panelists will have 20 minutes for the presentation, and then we will open for questions. Without further ado, and without any more jokes, Professor Dolin, you have the floor.
He is a good student, by the way. It's an honor to be here, honestly, and sometimes I don't know how I get included in these things, so I'll do my best. I'm going to focus on UPL, and I'm going to look at UPL, unauthorized practice of law, from an engineering perspective. So, I have a talk I give called An Engineer's Journey Through the Legal System, and it's really about the shock that I had when I went from Google to law school and then did my internship at a law firm, and just the different mentality that you come with. But at the end of the day, I think a lot of what's going on as we start seeing an injection of innovation and efficiency into the legal system is the engineers want to look to see how they can do things differently and better. And lawyers are steeped in the tradition that's necessary for the predictability, and that mentality kind of moves into the way that you implement law rather than the substantive law itself. So I think that there's a little bit of a problem as these hit. And one of the places that we see this the most would be about UPL and technology. So, I could use as an example, in our class I had Eddie Hartman come, who was the co-founder of LegalZoom, who's moving out internationally, who has had to fight UPL claims in all 50 states in the US. And the issue there is, what are these claims about? Who is bringing them? And where is the harm? So there's two aspects of UPL, and we all know this. It's the protection of the profession as protectionism versus the protection of the client to make sure that people are getting actual quality work. As an engineer, I come at this and say, why aren't we just looking at the work? Why aren't we just looking at whether or not the quality of the work is there so that we can inject the innovation and efficiency as we need to? So one of the signals that you look for is who's bringing these claims. So Professor Deborah Rohde at Stanford did a study of this, calling every single state and finding out who was bringing all this. It's like 90%, 95% of the claims of UPL are coming from lawyers. And what is the damage being caused to people? There is damage that comes to people when they're getting non-lawyer work a lot of times. It's just that is quite the exception for these claims of UPL. So I'm going to check my... So let me give you an example. If we have, and I'm really glad to hear that you guys covered all of these topics, and we went through these all in class. That's great. So look at document automation, and it's a decision tree. So suppose that your document automation system is just instantiating what a lawyer would do perfectly. It's a yes/no tree. You're asking a bunch of questions, and at the end, the document automation system is giving you a document filled out correctly, and it is exactly what that lawyer would have done. Is that unauthorized? All we did was take what was in the lawyer's head, embedded in the system, and created the same work product. So I challenge that is really something that we didn't want to have happen. So the point of UPL for me is looking at a realistic question of what are we comparing it with? And often what I'll hear is we're supposed to be comparing this with some reasonable lawyer standard. We know that there are better lawyers, and we know that there are worse lawyers. So we know that some lawyers, no one in this room, does crappy work. And the minimum work that lawyers are allowed to do is actually malpractice, at least in the US. I don't know the standards for Brazil, but so long as you are meeting some minimal competency level of work, the work can be bad. And we've seen people complaining about the work of other lawyers, let's say incorporation documents that have to be redone or this and that. So I asked the question, why should the software have to perform any better than the worst allowable attorney? So I'm coming at this from a UPL against technology, against document automation, that kind of. You can also raise these questions around non-lawyer professionals, like New York has this navigator system where people take you through courts and actually they do know how to fill out documents, but they're not allowed to help. Or there's this triple LT, this basically the equivalent of a nurse practitioner, but in law, and they are able to answer a lot of legal questions. So we know a lot of people can help with law, and they're not allowed to. If the software is doing bad, even if we assume in a particular practice area, would that justify removing software from all other practice areas? And in particular, we talk about access to justice, and we're looking at the common problems that people see, which would be something like wrongful eviction, consumer debt, non-contested divorce, for example. These are commodity types of legal problems, and it is pretty straightforward for software to do a good job on this. So why would we want to throw out software as a solution because you can think of an area where the software might not be able to do a good job? I'm just looking through my notes here to see. Yeah. If we see bad work from a lawyer, we don't argue that we should just prevent all lawyers from doing law. So if we see bad software that's also similar, that I would say, why would we ever think that we should disallow software to do the work? And that's just under the assumption that the software is not doing a good job. And then the question is, what are we comparing with? I have heard too many times the argument that people should have lawyers representing them. And there isn't the resource available. Societally, we don't provide the resources. Personally, they don't have the resources. And what's going on, a lot of the access to justice problem is that people are coming to court unrepresented, unaided, and they're up against maybe, let's say, a landlord that has an attorney in court. The judges struggle in the US to figure out a way to help people that aren't represented. So the argument here is not how would this person do with against a lawyer versus the software. The issue is whether or not the people that are coming unrepresented would do better with the software versus coming alone with no help at all. And it just has to be stressed again and again. The comparison here has to be against the viable, realistic, on-the-ground options that people have available to them. And certainly in the US, when we have millions of people a year who are not represented at all. The argument that it is unauthorized practice to have software help people with common problems that you could answer through a decision tree, it's unconscionable, and there's no other way to describe it. You have to look to see whether or not this person is better off with the software than against any other option they have available. And I would argue that more often than not, the answer is yes, they're better off, and that unauthorized practice claims are really hurting people. There's a list of advantages that you can have by using technology. For example, the low cost. you can identify problems when they happen, you can track them, make corrections, and then those corrections stay forever. You can certify the software if you want to, and once you've certified the software against a bunch of problems, then you have some degree of confidence that that software will continue to work in that area. Software is pretty good at doing triage, meaning it identifies whether or not your fact pattern goes beyond the ability of the software and simply says to you, I can't help you, you need to talk to a lawyer in this case. Okay, so if the software is reasonably good simply at identifying whether or not the fact pattern meets the software's capabilities, people are well served. So I think one of the ways that I would look at this is bringing in a notion from computer science called the Turing Test. The Turing Test is if you are, let's say, talking through a screen to something and you don't know if it's a computer or a person, and you can't tell the difference, then if that happens to be software and you didn't know it, it passed the Turing test, right? So I would say if I show you a piece of legal work product and you can't tell me if it was made by a technology or by a person, it's a pretty difficult argument to say that the technology shouldn't be generating the work product. So at the end of the day, and one of the things I talk about in class, and the nature of my research here is all about the ways that we try to measure the quality of legal work. And so again and again, across the legal system, these barriers to adoption of innovation and efficiency of technology come down to whether or not the quality of the work can be measured and shown to be as good as we might require to help people, that they are better off than they would have been without it. So, yeah.
Thank you, Professor. Now, Professor Gustavo Binenbojm.
Good afternoon, everyone. I am really honored and flattered to attend this meeting here at Harvard that brings together a number of renowned legal experts. So, first of all, I'd like to thank the organizers of this wonderful event, and thank you for the invitation, which proves that it is better to be friends with your former students than a great teacher. Well, I intend to share a few ideas about the dynamics of regulatory changes as a reaction to the appearance and expansion of disruptive technological innovations. Although my perspective is from the viewpoint of a developing country such as Brazil, I think that both the description of the stance of regulators and legislators and the legal standard that I propose for its control by the judiciary could be more widely valid on a global scale. So my starting point is that new business models based on innovative technologies bring about disruptive effects on certain markets, changing the behavior of consumers, the level of demand, and pushing prices down and quality up. To use Joseph Schumpeter's famous idea, a dispute arises between what he calls creative destruction and destructive protection. In other words, a conflict emerges between the improvement of consumers' welfare produced by innovation and the preservation of the status quo, which transform old regulation into an actual barrier to market entry for new players. Naturally, lawmakers and regulators could not have thought, for instance, of Airbnb's renting of private rooms when they drafted the hotel safety and urban zoning standards. Nor could they have thought of the use of smartphone apps such as Uber or Cabify for individual passenger transportation when they enacted rules for taxi licensing. Therefore, the reaction of corporations that dominate markets destabilized by disruptive innovations has been based on the defense of legality. That's to say, on the application of current legal frameworks as a way to prevent newcomers from entering their markets and to avoid both the loss of customers and the competitive pressure on prices. Simply put, the idea was to use the law as a barrier to entry. This circumstance explains why, in a very similar way, a New York judge imposed a high fine on the owner of a private apartment that had been receiving strangers for 3 days in return for payment using Airbnb, because his conduct was equated to running an unlicensed hotel. Similarly, courts in Belgium and Germany have declared Uber's activities illegal since they were deemed to be unlicensed taxis. In the same vein, the French law called the Tévenu law forces Uber cars to return to a base between trips and severely restricts the use of software to find customers on the streets. These examples resemble laws and local regulations issued in Brazil, which at first banned or severely restricted the activities of entrepreneurs operating within the sharing economy model. Therefore, what seems to occur in the cycle of disruptive innovations is a first stage where legislators and regulators tend to be reactive to them. They interpret the new in a way that makes it as close as possible to the old, pushing it into illegality and creative an incentive contrary to innovation. But why does this happen? I have some clues. First, because legislators and regulators have very often a bias against innovation. As new models disrupt and destabilize old schemes, they are inclined to defend the model they have built. Second, because they would have to acknowledge the incompleteness of their work and accept the criticisms and inputs of other institutions, such as antitrust agencies. In a certain way, regulatory obsolescence would be a kind of regulatory failure. Third, because legislators and regulators would have to be accountable for their own ignorance in assessing risks and potential benefits, which actually shines light on the uncertainties regarding the impacts of innovations. And finally, because sometimes legislators and regulators are captured by the regulated parties, which adds to the other factors in the protection of already established companies. It's interesting to note, however, that as a second stage in the cycle of disruptive innovation, something of a counter-reaction is seen from agencies in charge of antitrust enforcement. In Europe, for example, the European Commission has announced that it will challenge restrictive laws and judicial decisions as related to Uber before the European Court of Justice. Their main contention is that these regulations create artificial barriers to free competition and discourage innovation, which are fundamental principles of many different European treaties. To this effect, an outraged Neelie Kroes, then the Vice President of the European Commission, stated that these decisions were not about helping or protecting passengers. They were about protecting the taxi cartel. In Brazil, the antitrust authorities have been playing this role of competition advocates, exposing how the taxi industry benefits from regulations that create an artificial monopoly and unduly transfers income from consumers to service providers. However, as antitrust authorities do not have jurisdiction over laws and regulations, they lack the power to overturn them. So what happens? the conflict between innovation and regulation invariably ends up in courts with you. This would be a third stage in which the judiciary is urged to exercise control over restrictive laws and regulations. Judges will play the role of unlocking the channels of innovation and fostering the opening of markets close to the competition of new entrants. While in the first stage, judicial decisions usually constitute a reaction to innovation, here I intend to argue, normatively speaking, in favor of a proactive role of the judiciary in overcoming regulatory barriers. One might wonder whether the judiciary would have the necessary institutional capacity to face this challenge in favor of innovation. I present here some optimistic arguments regarding this capacity. First, judges are external players and are not committed to the bias of regulators. Second, judges are controllers and thus have incentives to point out regulatory failures. Third, judges have the power to overcome barriers to entry in defense of free competition, especially when based in studies of antitrust authorities who could act as amici curiae or expert witnesses. And last but not least, judges are more independent and less susceptible to be captured by economic agents already established in the market. From a normative point of view, it may be the case of defending a pro-innovation standard of judicial review that would work as follows. If the regulator establishes specific rules that do not hinder or prevent innovation, the judiciary should be deferential to those choices. But if the regulator remains inert or adopts standards that prevent the access of new entrants to the market, inhibiting or discouraging current or future innovation, the judiciary should take an active role, deeming this conduct suspicious of being an illegal barrier to entry. In this case, the standard must be more severe, requiring relevant explanations of public interest from legislators, regulators that could justify such norms. In Brazil, a few judicial decisions have been rendered under such standards. They have acknowledged that in some cases, regulator does become a true barrier to free competition and to the welfare of consumers. I'm glad to tell you that one of those decisions, actually the most brilliant one, was rendered by Judge Bruno Budar, who spent this academic year here in Harvard and is one of our hosts in this wonderful event. Clearly, judicial review cannot and should not be the last stage of the regulatory innovation cycle. Courts lack this expertise and experience to formulate new regulatory designs, mainly in scenarios marked by great uncertainty and lack of information. The role of the judiciary should be to open innovation channels and foster free competition to the greatest extent possible. The fourth and final stage should be the engagement of regulators and legislators in a sort of an institutional dialogue in which responses to problems and side effects arising from new technologies emerge. At this point, regulators and legislators will have to face what has become known as the Collingridge Dilemma. This dilemma involves the doubt between regulator at an earlier stage and inhibiting innovation, or regulating afterwards and allowing for the entrenchment of harmful practices that could not be easily removed anymore. In order to deal to deal with scientific uncertainties regarding the impacts of new technologies, regulators should preferably opt for minimalist standards. These standards should be of an experimental and temporary nature, allowing for adjustments and learning over time. In general, those pro-innovation standards often result in a regulatory asymmetry regime that favors the entry of innovative newcomers into the market. They also ensure minimal protection for consumers in terms of security, adequate information, and privacy, without the prior definition of models, technologies, or specific goals. The Brazilian Congress very recently enacted a law dated March 26, 2018, about the private transportation of passengers requested by users previously registered in applications. It seems to me that the Brazilian lawmakers were guided by these minimalist criteria and limited the scope of the law to the following points. It legalizes the private individual transportation of passengers registered in applications. It requires the hiring of passenger personal accident insurance and the general mandatory insurance, the PEVAT. It requires payment of local taxes and enrollment of drivers in Social Security, as well as a specific technical qualification for drivers. It establishes a minimum age of vehicles, and finally, it requires a criminal background check on drivers. This statute enacted by the Brazilian Congress seems to reflect, on the one hand, that the space opened by a number of judicial decisions should lead to a new regulatory framework that embraces new technologies and new sharing economy models. It also reveals a choice that responds to the will of the majority of consumers. On the other hand, the option for minimalist regulation also responds to the user's demand for protection of their safety, health, and the environment. A cautious choice which does not discourage innovation, but that seeks to minimize the risks arising therefrom, and also allows adjustments and learning in the face of a rapidly changing reality. This new law will be up to date at least until, soon or later, we all become users of autonomous cars. As put by Judge Isabella Ferrari yesterday, technology never waits for the law. And then the innovation cycle starts once again. Thank you very much.
Thank you, Professor. Now I turn to Professor Vitor.
So, good afternoon to everybody. First of all, of course, my most heartfelt thank you for the organization for inviting me to come here. It's a pleasure and an honor. All of you guys, students of Harvard, have made an amazing and remarkable job in this event. I've seen many events organized by long time enrolled professors that have not met 10% of the quality and the professionalism of the organization of this event. So thank you so much for inviting me, and congratulations for the job you've done so far. Oh, it's terrible to be the last one in the day. Everybody's looking very forward to go away and rest a little bit after so many good contents during all the day, and it's even harder to speak after two marvelous lectures as the ones that preceded me. I will try to address here a problem that we, administrative law specialists in Brazil, are facing, which is the conflict between the new and the old. And this conflict is even more highlighted in a contest where the old always tends to win, which I mean the public administration in Brazil. Public administration in Brazil is extremely tied to formal and traditional ways, which are not very much compatible with the technology developments that we have been facing. And one other thing that must be added, especially when talking in an American university, is that we have a French law tradition in our administrative law that has made Brazil much more French than the French. What I mean by that, France is the cradle of administrative law, as the one we know in Brazil. France has had an amazing academic development of administrative law up to the 30s. And Brazil has been influenced by the others that have stopped in the 30s, 40s. After that, France has faced a very remarkable development in the administrative law that has not arrived in Brazil. Brazil is still stuck with the classical and old French authors that are read in Brazil with a very different eye from the French eyes. So we have a lack of consciousness and some kind of psychoness in our administrative law, which is a problem. And even more a problem when we talk about technology developments that all the time challenge common and regular formalities of the public administration. Just to address a little bit, I'll be very quick about that. What is the problem? We are facing some challenges that are a huge challenge to the bureaucratic administrative structure of Brazil. Technology is transforming everybody's life. I don't have to go through it again. It is irreversible and irresistible. There's no way of trying to stop it. Thanks God. Alternative forms and new forms of interaction are coming into force and will not go away. And the traditional ways of acting of the public administration will always be in challenge of that. Therefore, we have three very loud screaming questions. When, why, and how to regulate? Where should the state impose itself and limits the liberty of the economic actors? That's a question that is very difficult to be answered in a much more flexible system like the US, and in Brazil, it tends to be almost impossible. To comment very simply, why is there any regulation? Since the movements of the independence of the United States and the French Revolution, mankind has determined that liberty is a value that must be preserved. And therefore, there has been always a struggle between state intervention and liberty. Basically, in very general lines, we can say that regulatory interventions are admissible when there is a market failure, the state must correct a misformation of the market. There is the necessity of achievement of public service goals, and by public service here I'm being very French, as a reference to activities that must be provided to the whole society for the benefit of the society and for the fulfillment of some fundamental rights of the society, and which are sometimes anti-economic, and therefore we need a regulation of the market in order to assure that the goals and the fundamentals of the public services will be achieved. Redistribution, in other case, paternalism, protection of the human being against the human being. Just a small joke in here, everybody saw that Wall Street Wolf movie. There is a scene where they are throwing a dwarf into a bowl. Don't know if you remember that scene. That is actually one of the most relevant cases of the Conseil d'État in France. There was a circus that had a special attraction, which was the throw of a dwarf. They put the dwarf in a cannon, and they used to throw the dwarf. And the municipality said, no, that's not allowed. That is horrible for the dwarf. That is horrible for society. You will not do that. And the circus said, well, I'm paying, and he's accepting. What is the problem? And the Conseil d'État has done a very remarkable precedent where they said, state is able to control people, to protect people against people. So paternalism in that in last case. Public security and public order, how open those terms are, and planning. Those types of regulation lead into two main forms of activity of regulation within the markets. First, the imposal, the creation of some market barriers, the creation of some state controls over the possibility of the inflow of agents in a given market. That may be the case of public services, where I must reduce somehow competition in some cases in order to achieve the goals of the public service. Natural limitations of the market, dependence on restricted public goods or natural monopoles. Interdependence of the market, financial markets, for instance, and asymmetry of information, capital markets. I just made here 4 large groups that somehow comprehend everything that we have in terms of market barriers. And after the establishment of some barriers, we have also some actions in regulatory fields that lead to restrictions of the liberty of the economic agents already within a certain market. For instance, control of the remuneration, like what happens in the public services with the establishment of price caps and definition of a precise tariff that cannot be overcharged by service providers. Limiting on the economic organization of some activities, for instance, with the unbundling of activities, and consumer protection goals or other any public policy goals, as we have seen in many other panels during this event. What's the problem? Those two forms of actions, the control of entrance in a market and the control of the agents within a market, are very much challenged by new technologies. We have new alternatives or forms of entering in the market. 10 years ago, to find a car that would be willing to take me somewhere, I would wait for a yellow car with a sign of taxi and call for it and hope that there is no other person. Nowadays, I can have an app and call the cab and call a car whenever I want. New forms of interaction. Economic agents are much more have a much wider space to define the terms of transaction. I don't have to wait for the state to determine how much I have to pay for the kilometer when I'm in a certain vehicle to be transferred from point A to point B. It is possible to have a much more designed structure where I can pay more or less depending on the time, depending on the type of vehicle that I'm using, depending on lots of information that are basically depending on what I want for the type of service that I'm willing to pay. New forms of allocation of risks. For instance, there has always been a myth that state must control, for instance, the taxi provision services in order to ensure public security. Now, with the apps, I can take the risk of the security, and if the car is not safe, I can simply use my app to make a statement about it, and it will reduce the chance of that driver to be providing the service to another person. New forms of competition. I have new agencies. I have new forms of interaction. For instance, we have now many apps for personal money loans. that are independent from the financial market. Up to some years ago, the only competition existing was the competition between banks. Now, individuals can compete in offering and in taking loans. And finally, new forms of remuneration. In the end of the day, how can the state, for instance, in Brazil, there's a federal law that limits the total amount of interest that may be applicable to a loan of money. How can I control that when I'm lending money to Gustavo through an app? It's very difficult. It's very difficult indeed. And even it can be absolutely inconvenient from an economic standpoint, because it is desirable that there are more offers of money within an economy. And it's also impossible to admit that I cannot charge Gustavo more than I would win in a bank investment. How to regulate those two completely contrary forces? What is to expect from the regulator? Brazil is absolutely not ready for that. First of all, the content of public order, which is a myth, is something that the Brazilian authorities further and further repeat, is very difficult to be understood. We can say that some actions violate public order. For instance, football fans fighting to each other. That for sure violates public order. But we cannot ensure that Uber is a violation of the public order. There have been many actions against Uber based on public order. That's something very hard to say. And it is a concept to which the Brazilian authorities are very tied to. So how are they supposed to have a decision based on a concept that is not clear and that is in constant change? It's the first point that is very difficult. The transportation apps, Uber, Cabify, and others, is a specific case. The use of regulation to taxes is normally based on the preservation of public order. However, how can one affirm that Uber or Cabify is a violation of public order? That's very difficult. We have to go to the understanding of new concept, as Gustavo correctly identified. Second, how to preserve the structure of markets and some public service obligations in this innovative concept. For instance, in Australia, there is already the offer of the collective public transportation within the last mile only through apps, because the last mile is the most expensive mile in public transportation. They already developed a system where the last mile is exclusively offered through apps. How we can put that inside the market without changing the regulation of the market? And how can we combine the new regulation with the existing regulation? That's a huge problem. By denying the development, it's not the most suitable solution, I think. What happened in Europe with Uber, with the recent decision of the European Court of Justice prohibiting the Uber in Europe, is something that I think that's not will not deal with the problem, because as Gustavo correctly mentioned, one regulatory response will lead to another answer from another perspective to another technology development. How and when should the state intervene to reduce asymmetries? Sometimes you reduce one asymmetry and create another. It is not the moment yet, but it may be the moment in few years or few months from now. I don't know what people is doing in the Silicon Valley. That new debt instruments and new securities will be offered through an app. Now we can control the flow, the inflow and outflow of securities through a system operated by authorized stock and exchange agencies. However, that may be not the case. There may be some developments. And what if those new developments are able to reduce or somehow mitigate the asymmetry of information that there is between the issuer and the purchaser of a given bond? It's something that must be answered by the regulatory authorities. And more, in the light of the Brazilian administrative structure, there is always the tendency of determining that the public administration is an end on itself. That's wrong. Administrative powers are a way to control, regulate, and organize the society. Therefore, open and pre-established answers are not the correct way. We have to go further into the questioning of the public administration in order to oblige them to establish what is the most correct way. And more, why must regulation be ex ante? Why must regulation be prior to the actions? Why can more room be left to antitrust control? That's an answer that in Europe is becoming a little bit clearer, but in Brazil we do not have this type of consciousness, because we think that good regulation is bureaucratic, paper-based, and done ex ante, done priorly. Maybe that's not the case. Maybe the state should give more liberty and control on an ex post basis. And final, how to update a Jurassic administration. By reading Gaston Geze, one of the most important French authors from the 30s, will not lead to an answer. It may be considered to be a joke, but there are many legal opinions that we receive from public attorneys, from public legal departments, that are based on arguments brought in the light by Geze in the 30s. It's not possible. That is simply not possible. And there must be a way to prepare the administration to answer those questions. What are some possible outcomes? We have to admit that the old is dying or dead, I would say. We have to face for something new. Our public administration must face something new and must be prepared to use new instruments of action. The paperwork is not working anymore. An Uber driver can go into the market without filling any paper. That's a crisis. That's in Brazil, a crisis. Who saw the picture brought by Judge Rafael yesterday? That is judge law in Brazil. That is a judge rule in Brazil, and that is any public administration office in Brazil. They love paper. How can they have an economic agent acting in a market without paper? That's a problem, and that is one of the outcomes that it must come, that we must face. Perhaps paper will not deal with the problems. Secondly, more space to rationality and proportionality. That means we cannot face a predetermined decision. If there is some, this one also works. Oh, nice to see that. One of the problems that we always face in Brazil is that we are desperate to find an overall catch-all solution. For instance, public interest. That must be in accordance with public interest. That's a phrase that is so vague as like, am I in favor of the cure of the cancer? Of course it must respect public interest, but what the hell is public interest? That's not clear. And that does not lead us into a predetermined decision. We must look into details of this situation and find a solution in accordance, tailor-made to the situation. And there is where proportionality will play a definitive role. Because the pros and cons, the balances and the cost-benefit of the decisions must be taken into account, which they are not in Brazil nowadays. In this, as a consequence of this affirmation, we have to accept that public administration must have a huge discretion. Brazil, we have a terrible fear of the discretion of the public administration. We always think that it is led to corruption, that is meant to everything that's bad. That's not the way. It is impossible to have a law standing for all the possible outcomes of the society. We have to admit that the administration must be empowered with the necessary tools to regulate society, and must use those tools with a certain level of discretion. And this discretion will not be based on the mood or on the desire of the administrator, will be on a very deep study of the situation in the light of proportionality and rationality. And in the end of all, confirming and agreeing in full with Gustavo, the judiciary will have a full decisive role on that, because the judiciary must change the drive in terms of control of the public administration. Nowadays, the control is based on legality, on strict illegality. However, strict illegality will never occur, will never exist. The control will have to be over proportionality and rationality. That not leading to the judge being responsible for the decision that seems to the judge the more proportional and the more rational. If the administration is not capable of addressing and motivating the most proportional and most rational decision, the judge must annul the decision and give the ball back to the administration for another decision that is duly grounded. That is an adjustment of the Brazilian administrative law that is fundamental for the development of the country. Without a regulatory system that is able to deal with the problems of the society, it will be impossible to not to be a developed country and not to be a reason of so many jokes that have been done along this week. So many times everybody laughed about some situations in Brazil, which is due to the lack of rationality and lack of development of our state. Our state must go forward and try as close as possible to follow the developments of the society. Thank you.
Thank you, Professor. We have a lot of time to answer questions, so I'm not going to act like Bruno. There's a question for Professor Ron Dolin from the audience. Professor Eric Navarro is asking, do we have already softwares capable to pass the Turing Test in legal reasoning?
No. You know, I'll take that question a little more broadly to just talk about the issue of just general machine learning and the role that it plays in the legal system, and kind of, you know, future prediction is really challenging. But you know, you look at as an example e-discovery, and there's some machine learning that goes in there in terms of picking the documents that are relevant to the litigation, and we started with search and term matching, and then we moved forward with some sort of learning algorithm, and then the algorithms get better and better, and they're faster and faster, and they're increasingly accurate. And the number of documents, of course, have forced this to happen because we couldn't possibly look over 100 million documents by hand, et cetera, et cetera. So actually, I was just talking about this yesterday in California, that this is an example of the way we were doing things. I'm going off a little bit, if that's okay. The way we were doing things in the past seemed fine. Now, for whatever reason, we introduced new technology. People complain that it's not working perfectly. That forces us to then go back and measure what the new system is doing against what the old system was doing, because it's not about the new systems being perfect. It's about the new systems being better than the old systems, but we never measured the old systems. When you do that then, and you're forced to use metrics, and you're forced to look at what we've been doing in the past, and you stop assuming that what we were doing was okay, we find that the new systems are actually faster, less expensive, and higher quality. That's common because of the inefficiencies that we had in the past. So now let's take some other examples. Mergers and acquisitions. If Google has 100,000 patents and they're looking at a company that has maybe 1,000 patents to acquire, is that a complementary set of patents? How do you know? You're not going to go through patent by patent by patent and try to figure all of the details out, especially if it's another country with a different patent classification system. So they're now automating the process of looking to see whether these patents are complementary, and then that now feeds into the target, the process, the legal process of doing that acquisition. Another example I'll use is contract analytics. I'll use Google as another example because I know it well. Sitting on 1 million contracts. Talk about a bank that has to capitalize based on its at risk. Well, how much is it at risk with its contracts? Who knows? You have 1 million contracts. Did you write it all down? I mean, a new question will come up in 5 years, and you're sitting on all of these contracts, and you're supposed to go back retroactively and figure all that out. So this is AI, and this is machine learning, right? This is the process of going through and figuring out how can I pull out known clauses that are written differently for every contract? How can I figure out certain pieces of information so I can pull out actual data elements and not just a general clause? And the sophistication of these systems is getting increasingly better. So let's see what the question was. No, but okay. As a micro answer, within a practice area, right? I can't tell you whether or not that analysis of that contract was done by a person or a human. I can find mistakes when people do it. I can find accuracies when machines do it. And typically speaking, the best systems that we come up with is a hybrid that uses each piece for the best that it can do. So, of course, we want to, I don't give you 1 billion documents and say, here, which ones did you want that meet your search? But I give you a ranked list of documents. So therefore, the ones that are most likely, the ones that you want, are shown at the top. And as a result of that, you then apply your human work to the stuff that's been aided by the computer, and we do pretty good at finding the information that we're looking for. So the Turing Test is really about whether or not the computers are supplanting humans, and I really like to look at it as that the computers are amplifying the experts that we have in law. So that on all scales of this, at all ends of this, so on the lowest end for access to justice, where a lot of that stuff is commodity work, and we see similar things happening over and over, we can use a decision tree, we can ask a question about whether this eviction was wrongful, we can ask whether or not, this debt has expired, not to do anything, etc. We can handle that pretty well with an expert system asking a bunch of questions. And at the high end, with your $2,000, $4,000 an hour New York lawyer, do you want that lawyer with or without judge analytics, with or without knowing which cases are commonly cited to in that court in this case? So you still need that expert, whether that expert is working directly with to get their briefs better or to give you more per hour. So anyway, at all ends across, the application of machines, in my opinion, are enhancing what a lawyer does. We want to increase the scale and outreach so that lawyers are doing a better job and helping more people for the same cost. So that's the long answer to a Turing test.
Another question for Professor Gustavo and Professor Vitor. In Brazil, lawyers can't advertise their services. It's a feature of our country.
We had that here until it was struck.
Really?
Yeah.
I didn't know that.
I'm not an expert in the history. It was First Amendment violation.
Okay.
Yes, yeah.
Jus Brasil, which is a website in Brazil, has faced some legal battles for providing legal advice online. What is your take on this?
Gustavo, what do you think on this? Well, I think that I still can't find a reason why lawyers cannot make advertisements in Brazil. I really don't know about it. Don't know the reasons of that. But we have to go into the details of what advertisement is, because, for instance, showing a banner with the logo of the law firm and mentioning the law firm is supporting a website or law congress or something like that is a form of advertisement, and it is admitted. I think that what cannot be done within the legal barriers of the legal regulation of law profession in Brazil is the face-to-face advertisement, where I can say that my law firm is better than Gustavo's because that or that. This type of advertisement, I think that is not allowed. Sponsorship, I don't see any problem. But it's very difficult to make comments on regulations that are not strictly complied with by anybody. So it's very, very difficult. I don't see any problem in a banner, as well as I don't see any problem in any type of advertisement. I don't know why we lawyers must be different from other professions.
Tell me if I'm talking too much. I would go back to what I was saying about UPL and to look to see who's being helped and who's being harmed. So, a lawyer that is an expert in a certain area that wants to let people know that that's available, I don't see the harm to the client on that one. Ambulance chasing, completely different. So when you're going after people that are vulnerable after something has happened and you're trying to say, I can help you right here, and they're not really able to then, in that case, pick well, that's still illegal here. I don't think that's being challenged, but advertising was challenged and showed up to be a First Amendment problem. But again, when are you helping people by advertising? And there's plenty of room to help people, I think, with advertising. So that just seems to me a good way to kind of break down. And then, when we looked at the regulations, it's, are we helping people by blocking Uber? And some of the regulations around the taxis was to, again, when is it protectionist and when is it helping people? Because we want the regulations that are there for, having insurance and good license and background checks, because that's protect people. So I think advertising is one of those issues. So the notion of competition is a whole other story about what the benchmarks are. That I'll leave that.
I will jump in the discussion because I think there's a legal site here in the U.S. which is really famous, but most of the Brazilians probably don't know about it. It's called LegalZoom. And what Jus Brazil is trying to do is something similar to LegalZoom, because they are trying to give legal advice with an online platform. So we are probably going to face the same problems that LegalZoom faced here in the U.S. And my personal opinion is that it's almost impossible that we have a lot of judges here, so it's almost impossible that the courts will not try to forbid this kind of practice in Brazil, online practice, on the basis of UPL, because I think it's a common knowledge in Brazil that lawyers should be doing the kind of work that lawyers should be doing, and not online sites. And we have the bar associations that are usually really trying to maintain the lawyers' work. So I think Jus Brazil is going to face a lot of problems if they try to do the same thing that LegalZoom try to do here in the U.S. Also, could you comment a bit more about LegalZoom and the problems that they face here in the U.S.?
I mean, they were being attacked by the lawyers and the bars as being challenging for the work that the lawyers were doing, and So they would typically, they've reached settlements in most of the states, and I haven't followed this really closely, but at the end of the day, if LegalZoom pushes hard enough, we kind of come up against, again, a First Amendment right as to whether or not they have the right to do this. And I think a lot of the bars end up settling because they're afraid that if push comes to shove, the bars are going to lose on this one. So okay, that's happening in the U.S. LegalZoom is expanding internationally, so they bought a law firm now in the U.K. because of the alternative business structure licensing that's allowed in Spain and in the U.K. What I really would like people to focus on is just whether or not people are being helped or hurt. Who's bringing the claim? Whether or not the work is actually useful. So, for example, LegalZoom cannot help you pick how to start your company. They can't guide you whether you want a corporation, an LLC, the different business structures, a partnership. They can help you fill out a form. But, in order to pick between these different types of corporate starting at a startup, 5 questions is plenty, and LegalZoom wouldn't be doing anything different than what a lawyer would be doing. Say, well, oh, you want this, you want that, you want that. This isn't rocket science, right? So it's frustrating to see that the software that could do a completely reasonable job at a fraction of the cost might be being blocked. So am I answering? Okay. LegalZoom loves me.
LegalZoom is a wonderful site here. But you wish you could, right?
That's another story.
So one last question for Professor Dolin. How has ABA been dealing with legal softwares, startup legal ventures? What's ABA attitude toward legal work being done by software? They've been doing badly, probably.
So I don't... The first question is, why do we care what the ABA thinks? And I don't mean that negatively towards the ABA. Okay. What I mean is that the membership is going down, and the question is whether or not, for any of the bars, how relevant are they? And where the bars are focusing on protectionism, they will be increasingly irrelevant. And this is, for those of you that know Innovator's Dilemma, we looked at it in class, this is what happens. Because the technology, as we already said here, the technology is not going to stop. And whether it comes through the bar or whether people find solutions to their problems outside the bar, that's really the issue. So what does the ABA think? And who is the ABA? So let's be clear about some of this. Where the ABA is looking at alternate regulations, a lot of people may well think that they need to make changes, and then it goes to a House of Delegates, and the question is who comprises the House of Delegates and how do those various members vote and why? So where the House of Delegates is made up of, it's not large firms that are fighting this, it is small solo firms that feel the biggest threat, and this isn't really any different than a mom and pop store being threatened by a Walmart. And I just don't think that protectionism is going to save them. So what does the ABA think about technology? Is that okay? The model rules were changed with some comments that say that part of competency in lawyering in the US is knowledge of technology and the implications of technology in terms of, how do you use it, how can you advertise on it or not, but also what you need to have best business practice within your own law practice. So there's a certain level of support. UPL is not a professional responsibility rule, right? It is a state statute, right? I mean, because obviously the bars can't regulate non-lawyers. So this, and different states do this differently, and so the ABA's opinion on UPL may or may not be relevant because at the end of the day, they're not controlling anything that each individual state is wanting to do. So I think typically what I have seen in the ABA is that the heads of the ABA, the presidents of the ABA, et cetera, have increasingly tried to push technology because of the vast, deep concern for the access to justice crisis that's happening in the US, where millions of people are unrepresented. The only way to scale a solution to this is through technology, and they know it. The question is, what does that do to the profession, and how are we going to actually handle this transition towards solving people's legal problems, that just inevitably means that a lot of types of lawyering no longer need to happen by humans. So, the TBD, to be determined. Yeah.
We're going to end with this question. I hope you all can reflect about these questions that we discussed here today. We thank you all, the panelists, all the professors. Thank you for coming. And that's it. It's the end of the day.
Maybe next time we can arrange something in Brazil.